Hello everyone, this is Vinita Nair from Vinod Kothari and Company. And today in this video, we will be discussing on the minimum public shareholding norms that are applicable to listed entities. So what all, are the components of minimum public shareholding, and what is the threshold that needs to be maintained? What is excluded? What is included? What happens if there is any breach of minimum public shareholding norms, whether it becomes culpable immediately, whether it attracts penal provisions immediately. If yes, then what are the penal provisions? In case someone has to meet the MPS norm, what are the various manner in which an entity can meet the minimum public shareholding norms? All of this becomes extremely relevant for listed entities, and that is what we intend to discuss in this video. Before proceeding, if you want to get regular notifications on lectures and videos on corporate laws of your interest, then please do like, share, and subscribe to our channel. This video or this discussion is mainly for academic purposes, given its relevance for listed entities, and it is not intended for solicitation of any professional assignment. Now, when we talk about minimum public shareholding, we need to first understand, as the term suggests, it seems to indicate the kind of minimum quantum of shareholding which needs to be held by public, and therefore the meaning of the term public and hence public shareholding becomes quite important. Now, this is something which is defined in the securities contract regulation rules, where public means any person other than promoter and promoter group, and other than subsidiary and associates of the company. So excluding the promoter group and subsidiaries and associates of the company, the persons who are holding the shares would be identified as public. And therefore, public shareholding has been defined to mean as equity shares of a company which is held by public. Thereafter, there is also two explanations which are given. One in relation to depository receipts in the form of ADRs, GDRs. If those have been issued by the listed entity, what will be the impact on the public shareholding? So the shares which are underlying the depository receipts would be considered as a part of public shareholding only if the holders of such depository receipts are able to give the voting instructions to the custodian, and these depository receipts should be listed on an international stock exchange. So only if both of these conditions are fulfilled, in those cases, the shares underlying the depository receipts will be considered as part of public shareholding. Otherwise, this will be forming part of the non-promoter, non-public shareholding category. Now, where a company has an ESOP scheme which is being implemented through the trust route, in that case, the quantum of shares which are held by the trust person to the ESOP scheme, which will not form part of the public shareholding. So once we have understood the concept of public and public shareholding, we also saw that there is a reference to not being a promoter or promoter group. So a public is someone who is not a promoter and not a promoter group. Therefore, meaning of the term promoter and promoter group also is very relevant to understand. And for this, we have to refer SEBI ICDR regulations, which defines a promoter to include a person who has been identified as a promoter in the draft or the final offer document filed with SEBI, or who has been identified as a promoter in the annual return filed with the registrar of companies. It will also include a person who has control over the affairs of the issuer, direct or indirect, whether as a shareholder, director, or otherwise. It will also include a person with whose advice, directions, or instructions the board of directors of a company is accustomed to act. Of course, it doesn't include someone who is acting in a professional capacity, but wherever there are instances where the person is accustomed to act basis the instructions of one particular entity or person, that entity or person will be regarded as a promoter. There exists a carve out for institutional investors, even if they end up holding 20% or more of equity in that company, unless the other conditions are fulfilled. So if there are scheduled commercial bank, mutual funds, venture capital funds, or insurance companies, or foreign portfolio investors, excluding individuals and family offices, etc., even if they hold 20% or more of capital, they would not be identified as a promoter unless the other conditions prescribed, that is, there is an element of control, or they have been identified as one in the offer document, etc., has been fulfilled. Now, the meaning of promoter is also relevant because basis the nature of promoter that you have identified, you will define the promoter group. So promoter group, again, as defined under ICDR, includes the promoter. And where the promoter is an individual, it will also include immediate relatives of the promoter, which means the spouse of that person, parent, brother, sister, child of the person or of the spouse. So the immediate relatives ambit has been defined. They would be identified as promoter group. Thereafter, you move to the entities where this promoter individual or the immediate relatives have an interest. So any body corporate in which the promoter or their relatives hold 20% or more of the equity share capital, or if the HUF in which any of the promoter or relative is a member, if that is holding 20% or more, then that body corporate also is identified as a promoter group. Now, this body corporate which has significant holding from the promoters or their immediate relatives, wherever this particular body corporate further holds 20%, that also will be identified as a promoter group entity. Now, when your promoter is a body corporate and is not an individual, so we first understood that if the promoter is an individual, my ambit of promoter group would include the immediate relatives and the entities where this particular individual promoter and the relatives hold 20% or more, and such other entities in which these entities invest 20% or more. But where the promoter is a body corporate, in that case, my scope of promoter group entities would firstly comprise of entities one level above and one level below, which is my holding company and my subsidiary companies. Then the companies in which this entity, the promoter entity, holds 20%, which means associate entities of the promoter entity. Then body corporates that hold 20% in the promoter entity, which means entities exercising significant influence over the promoters will also be identified as the promoter group entities. Any HUF or firm in which aggregate share of promoter and their relatives is more than 20%, then those will also be included as a promoter group. This will apply, of course, if the promoter is an individual. Now, there is also a residual criteria, which is any other persons who have been identified as promoter group in the shareholding pattern filed by the listed entity. So that is again a residual clause which has been given. And there exists carve out for certain institutional investors. So for example, where the scheduled commercial banks or mutual funds or venture capital funds, etc., if they hold 20% in the promoter entity, they will not be identified as a promoter group entity. So there exists a kind of carve out for institutional investors. Now, when you talk about minimum public shareholding norms, what are these norms is something prescribed under the Securities Contract Regulation Rules of 1957. And it mainly prescribes under Rule 19, Sub-Rule 2, what is the quantum of minimum offer to be made to the public and allotment to be made to the public when the company goes for listing. And this threshold or this quantum has been prescribed looking at the post-issue capital of the company, which is calculated at the offer price. So if that is up to 1600 crores, then at least 25% has to be offered and allotted to public. Where it is from 1600 to 4000 crores, then in that case, such percentage which is equivalent of rupees 400 crores is something which needs to be offered and allotted to public. This may not be 25%, but in that case, you have to bring it or increase it to 25% within 3 years from the date of listing. Similarly, if the quantum being offered or the post-issue capital is more than 4,000 crores to 1 lakh crores, in that case, 10%, at least 10% of the capital has to be offered and allotted to public. And again, you will have the time frame of 3 years from the date of listing to increase it to 25%. If the post-issue capital being offered is more than 1 lakh crores, in that case, such percentage which is equivalent to rupees 5,000 crores has to be offered and allotted to public. And thereafter, the company will have a 5 years timeline from the date of listing to increase it to 25%. This timeline has been given because SEBI acknowledges the fact that in case of large issuances, it may not be feasible for the companies to have the public shareholders immediately at the time of offer. And therefore, a time frame of 3 years and 5 years respectively has been given from the date of listing to enable the listed entity to increase the public shareholding norms. Now, once listed, it's a continual listing condition in terms of Rule 19A of Securities Contract Regulation Rules, as well as Regulation 38 of Listing Regulations, wherein the listed company at all times have to maintain at least 25% of minimum public shareholding. In case this minimum public shareholding falls below the threshold of 25%, in that case, it doesn't become culpable immediately. It does not attract penal provisions instantly. There is a timeline of 12 months, which is available for the listed entities to bring it back or restore the MPS to 25%. But in what manner you can achieve it is also something which is prescribed by SEBI in terms of circulars issued from time to time. The recent one being that issued in February 2023, where it indicates that you can increase the MPS norms by way of a public issue, by way of an offer for sale by promoter and promoter group entities, either through prospectus or through stock exchange route. There can be rights issue or bonus issue to the public shareholders. There can be qualified institutions placement where you allot the shares to qualified institutional buyers in terms of ICDR, or there can be a sale of shares by promoters or promoter group in the open market in the manner prescribed by SEBI. One of the other means is to increase the public shareholding through the ESOP route, because that will result in the dilution and there could be an increase in public shareholding. However, that is subject to maximum of 2% of the paid up share capital. There is also an option of transferring the shares by the promoter and promoter group to an exchange traded fund, which is managed by a mutual fund, but there is a maximum cap of 5% of paid up equity of the listed entity. So these are the manners in which an entity can achieve a minimum public shareholding. In case it tries to achieve in any of the other way, for example, if it does a preferential issue to some person, in that case, it will not be in accordance with this circular and therefore will be considered as a violation or contravention of the provisions of SCR. Now, what happens if there is a potential breach? Now, the breach could be either in the form of wrong classification as public shareholder, breaching the NPS norms and not bringing it to the 25% threshold in the manner within the timeline prescribed, not reaching the MPS norms in the manner prescribed. So in each of these cases, it will be considered as a contravention, thereby attracting the penal provisions. Now, the penal provisions have been prescribed under Section 23E of Securities Contract Regulation Act, which gives a minimum penalty of 5 lakh subject to a maximum of 25 crores. And in October 2017, SEBI had also delegated this power to stock exchanges, whereby the stock exchanges could levy the fine and take action against the entity and the promoter group entities for breach of MPS norm. So where the period of non-compliance is up to 1 year, in that case, there is a fine of 5,000 per day, and the promoter and promoter group shareholding in that particular listed entity gets freezed till the date of compliance, and the promoter group individuals as well as the directors will not be able to take up any new position as a director in any other listed entity. Now, where this period of non-compliance is for more than 1 year, in that case, the fine stands increased to 10,000 rupees per day, and there is a freezing of the entire demat account of the promoter and promoter group. So the shares held in this listed entity and all other investments of the promoter and promoter group will be frozen by the depositories, and the restriction of not taking up directorship in any other listed entity will continue to apply to the promoters, promoter group individuals, and the directors. So as you can see that the requirements of law are very onerous, and there is again a prescribed manner in which the compliance can be achieved. So therefore, this becomes very relevant for the listed entities to ensure at all times correct classification as public shareholders and meeting the threshold of 25% at all times. We hope that you found this video useful. Please subscribe to our channel for more such videos. Thank you.